Good afternoon, everybody. I'm seeing some of you asking whether we're on. Yes, we're very much on. My name is Annabelle Njoki. I am the chair of the mentorship subcommittee, which is under the Member Services Committee, convened by our VP, Faith Odhiambo. Welcome to today's webinar. We're going to be facilitated by Stadler Trengov. Mr. Stadler is an amazing individual who I believe you've all been looking forward to hear from. And I'm just going to give you a brief intro or a bio on him before we delve into the presentation. So Stadler is a South African and a graduate of the University of Stellenbosch and New College, Oxford. He worked in private practice in Cape Town, and in January 1998, joined the United Nations as a legal officer. His work over the last 25 years has mainly been in the area of international peace and security, international criminal tribunals, the work of the General Assembly, Economic and Social Council, Security Council, and their subsidiary bodies, as well as the work of the United Nations Environment Programme. In the area of peacekeeping, Mr. Trengov helped negotiate the agreements that set up the United Nations peacekeeping operations, including in Sierra Leone, Eritrea, and Ethiopia, and the United Nations mission in Sudan. As liaison officer for the Special Court for Sierra Leone, an international court set up in January 2002 to prosecute the most responsible for the serious violations of international humanitarian law and crimes against humanity committed in Sierra Leone since 1996. He visited the capital Freetown and assisted in the arrest and transfer of the former president of Liberia, Charles Taylor, to the Special Court in March 2006. Between November 2006 in August 2008, Mr. Trengov served as senior legal advisor to the United Nations peacekeeping operation in Khartoum, Sudan. Between 2008 and 2017, Mr. Trengov provided legal advice on the work of General Assembly and the Economic and Social Council, as well as constitutional questions under the UN Charter. He has also served as legal advisor to several international conferences, including the Financing for Development Conference in November 2008 in Doha, Qatar, the 4th United Nations Conference on the Least Developed Countries in May 2011 in Istanbul, Turkey, and the Rio 20 Conference on Sustainable Development in Rio de Janeiro in June 2012. He was involved in the setting up of commissions of inquiry, including the inquiry established to determine the facts and circumstances surrounding the assassination of Benazir Bhutto. In 2010, he visited Baghdad to discuss commissions of inquiry with the government of Iraq. Currently, he serves as principal legal advisor to the United Nations Environment Programme in Nairobi, where he coordinates and oversees legal and procedural support to the UN Environment Assembly, committees, and intersessional bodies. This includes legal support to the recently established Intergovernmental Negotiating Committee to establish an international legally binding instrument to combat plastic pollution, including in the marine environment. Stadler, welcome. Feel free to take it away.
Thank you very much, Annabelle. You can hear me?
Yes, we can.
Great. So this afternoon, I'm going to speak about the practice of law in international institutions. And if I could just have the first slide, please.
Kindly confirm it's visible.
Yes, but you need to go up. I think you are, that's fine. Just go up to the first slide or the second slide, please. Second slide. Great. Next one. Great. Thank you. So what am I going to be speaking about this afternoon? I'm going to be speaking about the United Nations as an institution, as well as the United Nations family, what that means, the applicable law of the United Nations and its funds and programs. Then I will speak about the Office of Legal Affairs at United Nations headquarters as the Central Legal Service, where I served for 18 years. Then I will speak a bit about the legal offices of UN funds and programs. Then I'll tell you a bit about myself. Then I will segue into the UNEP Law Division and what that does. And then if any of you are interested in joining us, I will speak about how I get a job at the United Nations. Next slide, please.
Sorry, Stadler, I seem to be having a problem there.
There we go. So the United Nations has 6 principal organs. 5 of them, I think, are pretty well known to you. The General Assembly, that consists of all the member states of the United Nations, that is 193 member states. The Security Council, that consists of 5 permanent members, UK, US, Russia, China, and France. The Economic and Social Council, that consists of 57 members, that is elected by the General Assembly. The Trusteeship Council, which is pretty much forgotten about these days and has a very, very limited mandate. Its mandate is practically speaking over. The Trusteeship Council helped territories under the trusteeship system attain independence. And then there is the UN Secretariat, or the bureaucracy. And these are based at UN headquarters in New York. The 6th principal organ, the International Court of Justice, the ICJ, is located at The Hague in the Netherlands, and its primary goal is to help adjudicate upon and resolve disputes between states. Next slide, please. Now, in addition to the 6 organs created by the UN Charter, or the principal organs that I've just described, we also have United Nations funds and programs, such as my own United Nations Environment Programme, UNHCR, which stands for the United Nations High Commission for Refugees, OHCHR, which stands for the Office of the High Commission for Human Rights, UNICEF, which is the Children's Fund. And these funds and programs are large organizations in their own right, but they were created by the General Assembly and report back to the Assembly. In addition, we have specialized agencies. These are separate, independent organizations that were created by treaty, including organizations such as the World Health Organization, the World Intellectual Property Organization, United Nations Education, Scientific and Cultural Organization, UNESCO, and also FAO, the Food and Agricultural Organization, and a few others. These are, to reiterate, separate international organizations that do not report to any of the principal organs of the United Nations. And then you have treaty bodies that are really the cousins of the United Nations, such as the United Nations Framework on Climate Change, where the Secretariat is provided by the United Nations, or Environment, which has a Secretariat, like many other multilateral environmental treaty bodies, that is a Secretariat that is provided by UNEP. Next slide, please. Now, what is the applicable law? In other words, what law do we apply? First of all, as UN lawyers, we are governed by the United Nations Charter. The United Nations Charter remains important because it addresses, for example, questions relating to membership of the organization, who can become a member state. And it also addresses important issues relating to international peace and security, what the General Assembly can do, how the principal organs are constituted. But the United Nations Charter still has provisions that membership is concerned, the Security Council of the United Nations under Article 4 of the Charter has to approve membership, the membership application, and sends a recommendation on the membership application to the General Assembly. Why is that important? Because the 5 permanent members of the Security Council, again, Russia, US, UK, France, and China, can veto a recommendation for membership in the United Nations. Currently, membership stands at 193 member states, but there are those, such as the State of Palestine, that have an application pending before the Security Council. Then we have, so the Charter of the UN governs our work. Then we have the resolutions and decisions of United Nations bodies, such as the General Assembly and the Security Council. The General Assembly, for example, approve our staff regulations and rules. The General Assembly has, for example, taken a position that our United Nations logos can only be used for official purposes. They cannot be used for commercial purposes. On political issues such as Taiwan, United Nations General Assembly, going back to 1973, decided that the only government that we would recognize would be the one in Beijing. And because of a General Assembly resolution on what we call One China, the United Nations has no form of relations with Taiwan that it regards as a province of China. Similarly, when Russian aggression against Ukraine broke out, there were General Assembly resolutions on this topic that govern our work in this area, and that labeled against Ukraine as exactly that. And therefore, our engagement in Ukraine is governed by General Assembly resolutions. Similarly, when Russia moved into Crimea, the General Assembly adopted a resolution saying that we in no way should recognize that occupation, and thus for UN purposes, we still regard Crimea as part of Ukraine. We also apply international law that includes customary law and treaties, which we do on a daily basis, especially one important convention called the 1946 Convention on the Privileges and Immunities of the United Nations, that I will get back to later in the presentation, that protects our immunity, and where under that convention, we are granted immunity for purposes of the official functions that we perform. Indeed, the General Assembly has also adopted specific mandates for the UN funds and programs. There is a specific mandate for the United Nations Development Program, UNHCR, OHCHR, UNEP. All of them have mandates, and all that we can do is governed by that mandate. We cannot go outside that mandate. Similarly, the Security Council has adopted mandates for its subsidiary bodies, its peacekeeping operations, such as the UN mission in South Sudan or the UN mission in Kosovo, where there are specific instructions by the Security Council as to what that mission can and cannot do. And it is up to lawyers to interpret that mandate when actually implementing the mandates on the ground. And then there are our internal rules and regulations. We have procurement rules that require interpretation. There are United Nations general conditions of contract that govern all contracts that we enter into that have to be defended and interpreted. Next slide, please. Now, the Office of Legal Affairs at United Nations headquarters, which was, as I said, my home for 18 years, is the central legal service of the organization. And it provides legal advice to the Secretary General, Secretary of Departments, and offices, funds, and programs, and other United Nations organs. The Office of Legal Affairs is headed by the United Nations Legal Counsel. He's a pretty important guy. Currently, it is a Portuguese gentleman known as Miguel de Serpa Soares. And the Secretary General of the United Nations normally has a very close professional relationship with the Legal Counsel, because the Secretary General is always of the view, whether that is the current Secretary General, Antonio Guterres, whether it was Ban Ki-moon, or whether it was Kofi Annan, or whether it was Boutros Ghali, or going back Perez de Cuellar, or even further, it is always important for a Secretary General to know that when he acts, or when he expresses a view, when he opens his mouth, when he makes a statement, that what he is saying is legally defensible and consistent with international law. Now, who are the clients of the Office of Legal Affairs? Who do we advise? Well, at UNHQ, as well as throughout the world at other UN offices, we have the Department of Management. The Department of Management is probably the most important department in the UN because it is that department that runs the organization on a daily basis. They deal with human resources, budgets, administrative issues, finance, procurement. So the lawyers, for example, would advise on human resource questions, the implementation of the United Nations regulations and rules. We can advise on procurement. And at the UN, we also have administrative tribunals. So if you are a dissatisfied staff member, then you can go to an administrative tribunal and you can make a case against the administration. And the role of the Office of Legal Affairs is to defend the Secretary General, to defend the United Nations before the Administrative Tribunal. Then there is the Department of Political Affairs and Peacekeeping. It is this department that has offices throughout the world in the hotspots, whether that is in the Middle East, whether that is in Sudan, the Congo, West Africa, where we had many peacekeeping operations. But these are the people that are in the hotspots, together with the Office for the Coordination of Humanitarian Affairs that coordinates humanitarian delivery. And for obvious reasons, lawyers play a very important role, primarily because we defend the international status of the United Nations in these hotspots, which I will come to later. We defend the international status of the staff working in those areas, because while we respect local law, we are not subject to local law. We are subject to our own legal regime as set out, as I explained before, in the United Nations Charter, in resolutions of our intergovernmental bodies, in international law and treaties, and in our own internal regulations. So that means that that is the law that governs us. And sometimes countries do not like that. They do not like our independence. They do not like the fact that we operate pursuant to our own legal system. And it is therefore important for the lawyers to step in and to defend staff working on ground. We also work for the Department of General Assembly Affairs and Conference Services. And here again, what I will describe later in the presentation is that rather like in courts, you have criminal rules of procedure and civil rules of procedure. United Nations intergovernmental meetings also have rules of procedure that govern their work. And the role of lawyers is to interpret, protect, and defend these rules of procedure for intergovernmental meetings. Then we have our Office of Internal Oversight Services that is really there. Auditor General, they conduct investigations. It's not always a particularly pleasant area of work, but it's a very interesting area of work. And here in particular, if the Office of Internal Oversight Services is of the view that an investigation merits criminal prosecution against a particular individual, then the Office of Legal Affairs would support in that endeavor in order to bring, say, a recalcitrant staff member to justice. Then we provide legal advice to the Executive Office of the Secretary General. That is usually very, very high level. That is done by the United Nations Legal Counsel, who goes upstairs to see the Secretary General. And as I said, every Secretary General wants to ensure that everything he does and he says is consistent with international law. And then as far as the UN funds and programs are concerned, as I will explain later, they have their own legal officers, but the Office of Legal Affairs, as the central legal service of the organization, does provide a lot of legal support to them. Next slide, please. So specifically, the Office of Legal Affairs prepares legal opinions and studies on the interpretation of the Charter and on the interpretation of public international law. And again, for example, if a particular territory were to apply for membership of the United Nations, then that membership application would go through the Office of Legal Affairs. If the Secretary General needs a particular interpretation of a provision of the Charter, then he would get it from the Office of Legal Affairs. Consistency is key, precedent is key. So whenever you do an interpretation of the Charter or the interpretation of public international law, then you have to also look at what precedents exist. And so we as lawyers delve into precedents going back 70 years to the beginning of the organization to make sure that what we are saying is consistent with what we were being said before, or if we change our opinion, that we have a good reason to do so. Preparing legal arrangements for and providing advice on legal aspects of United Nations peacekeeping operations and other operations and activities. When the United Nations goes into a country like South Sudan or goes into the Democratic Republic of Congo, which it did in 1999, or in Sierra Leone in 1999, there is usually an agreement called a Status of Forces Agreement that is concluded between the United Nations and a host country that sets out the legal framework for our engagement in that country. And it is the Office of Legal Affairs that is responsible for negotiating that legal framework, which I have done on many occasions. I negotiated the agreement with Sierra Leone, with Sudan for the mission when it was one country, for the Democratic Republic of the Congo, etc. But those legal arrangements, in essence, consist of what we call a Status of Forces Agreement. Then, of course, there are many other agreements that follow the Status of Forces Agreement when we enter a country, including a lot of contracts for procurement, because when we move into a country, we have to build premises, so we need bricks, we need cement, we have contracts for architects, builders, we need water, we need communications equipment, etc., etc. So there's a lot of legal work when we move into a peacekeeping operation. Preparing draft rules of procedure for UN organs. I've touched upon that briefly. As I've said, United Nations intergovernmental bodies, like courts of law, have their own rules of procedure. We prepare that. Again, I've touched upon providing advice on UN privileges and immunities, including the Convention on Privileges and Immunities. So we advise on that. And then this is important, asserting and waiving privileges and immunities of the organization and relevant personnel as appropriate. And I will go a little bit about my own history as to how we've done that. But for example, if a United Nations staff member has to, for official purposes, testify in a court of law concerning her or his work, then waiver of privileges and immunities is required for that testimony to occur in a court of law. Why? Because testimony in a court of law can expose a UN staff member to legal process, such as prosecution for perjury. So we are very insistent that when a United Nations staff member appears before a court of law and is testifying under oath, there be a waiver of privileges and immunities. If cooperation is simply a discussion with a government official, say a Kenyan government official, then that would not require a waiver of privileges and immunities. We also believe in asserting privileges and immunities because that is a key to our independence as an organization. So, for example, if a government official doesn't like what a particular, we will of course investigate, but we can also assert our independence and say, no, you cannot arrest that person, you can't touch them, because what they are doing is official business of the organization. That also applies to our premises that are immune from search and seizure, and we have to agree to people coming on our premises. It is not simply that people can demand to enter our premises. And then we prepare what we call host country agreements and other legal instruments. So if we have a United Nations office, for example, in Thailand or whatever, then again, there will be an agreement that sets out the legal framework for the activities, for our activities in that particular country, and also provides for the immunity of our premises and the application of the Convention on Privileges and Immunities. Next slide, please. We also have in the past developed legal frameworks for the establishment of judicial and non-judicial accountability mechanisms. What does that mean? Post the horrific events in the former Yugoslavia and Rwanda back to 1993 and 1995, there were international criminal tribunals established. One was called the ICTY, the International Criminal Tribunal for the former Yugoslavia, that was based out of The Hague. And the second one was referred to the International Criminal Tribunal for Rwanda, that was based out of Arusha, Tanzania. The Office of Legal Affairs drafted the statute for the Tribunal for Yugoslavia, which was then adopted by the Security Council. And then the statute for the ICTR, the Rwanda Tribunal, was actually developed by Security Council legal experts, relying heavily on the Yugoslav Tribunal statute, and then adopted also by the Security Council. We assist in practical implementation, meaning that we have supported the appointment of judges, the registrar of these tribunals, and the prosecutor's office. Obviously now, with the establishment of the ICC, that is an independent body that is not UN, this is perhaps less important. As far as non-judicial accountability mechanisms are concerned, we have set up commissions of inquiry, which are often there to determine the facts and circumstances of specific events. I was involved in the establishment of the Commission of Inquiry surrounding the events relating to the assassination and death of Benazir Bhutto. Then we prepare legal opinions on administrative law. Again, that's staff regs and rules. We provide legal advice on procurement and contracts and the negotiation of contracts, which is fairly straightforward. And then we provide legal advice on the resolution of disputes with commercial suppliers. Now, importantly, the United Nations is immune, as I have stated, from local law. However, in the contracts with contractors, which is also a requirement under the Convention on Privileges and Immunities, we have to provide for some form of arbitration. So contracts with contractors do provide for arbitration under what we call the UNCITRAL rules. And then if there's an arbitration, it is the UNCITRAL rules that will apply. The United Nations is often reluctant to go into arbitration because arbitration can be very, as many of you know, arbitration can be messy, very difficult, and very time consuming. And often at the end of an arbitration, it is arbitration. So not everybody gets, you know, what they want. Next slide, please. So we provide legal advice on the name and emblem of the United Nations. As I've said, that is, the name and emblem of the United Nations cannot be exploited for commercial use. So we've had cases where you had United Nations driving licenses floating around. That was all illegal. We had to put a stop to that. United Nations dry cleaners, United Nations restaurant, you name it. It cannot be used for commercial purposes. Member states cannot use our name for commercial purposes. Office of Legal Affairs also assists in the preparations of draft international conventions. So, for example, the Rome Statute, the Statute of the International Criminal Court, was prepared by the Office of Legal Affairs and presented at the Rome Conference in 1998, where it was eventually adopted. Importantly, under the Charter of the United Nations, treaties can be deposited with the Secretary General. So we serve as the depository for many treaties. At the end of the treaty, you have what they call final clauses that identify who will assume responsibility for the ratification, for the notifications concerning the signature, accession, and ratification of treaties. Who gets that information? The Office of Legal Affairs is often assigned as depository. Why is that important? Well, once you have a certain number of signatures and ratifications, then a treaty can come into being. And often, you know, at a treaty event, they will say, well, there are 150 something signatures and ratifications of a particular convention. That's usually done by the Office of Legal Affairs. We also advise on treaty law and practice, and then we also provide support on what we call the final clauses of a treaty. That is, who can sign the treaty? Is there a dispute resolution provision in the treaty? What is the provision on accession? What is the provision on ratification, etc.? Next slide, please. Now, I'll tell you a little bit about my experience in the Office of Legal Affairs for a few minutes that hopefully can kind of give you a window into what legal officers do. So I joined in 1998 at United Nations headquarters, and I did a lot of private law to begin with. The UN in 1998 was still dealing with the mop-up operations of our missions in the former Yugoslavia and also in Rwanda. So there were a lot of outstanding claims that had to be settled, contractual disputes that had to be resolved. I remember one of the contractual disputes I had was that a contractor had used one of our cranes that we were leasing, and he was lifting a large piece of equipment with this crane, and he didn't know how to operate the crane, and so the crane came crashing down. Fortunately, he was not injured, but the crane itself was a write-off. And then, of course, we had to handle the dispute between the owner of the crane and ourselves because we were leasing the crane. So I did a lot of private law. Again, that was a cleanup operation from Bosnia-Herzegovina and the former Yugoslavia, as well as Rwanda. And then from 1999 to 2006, I was still at headquarters, but was doing a lot of privileges and immunities where we were defending the independent status of the organization in various parts of the world, defending the privileges and immunities and status of our staff. And also it was a period of tremendous growth in the organization. After what happened in Yugoslavia and Rwanda, peacekeeping operations, that was where we send peacekeepers into particular countries. Peacekeeping operations were largely discredited because they'd failed to stop the genocide in the former Yugoslavia and in Rwanda. But then Kofi Annan, who himself was a peacekeeper, did a wonderful job of reviving peacekeeping, and we sent peacekeepers into Sierra Leone, Liberia, Cote d'Ivoire, Democratic Republic of the Congo, and then we had what we called governance operations, where we actually governed territories in East Timor and Kosovo. And so I was involved in helping to negotiate the agreements that set up these operations. And then I was desk officer for ICTY and the Special Court for Sierra Leone. ICTY and ICTR were subsidiary bodies of the Security Council. They had enforcement powers. So if a judge wanted to see someone, then member states had to comply. If they issued an arrest warrant for an indictee, then member states had to comply. And actually, most of the indictees of the ICTY and the ICTR were actually arrested and put on trial. What was my role as legal officer? My role as legal officer was mainly to help the prosecution if they wanted UN documents. It was also to help defense counsel if they wanted UN documents. It was to help the registrar's office in the smooth running of the registry, and also to help draft what we call sentence enforcement agreements with member states, because once an indictee had been convicted and sentenced, that indictee was sent to another country where they served their sentence, and we had to have agreements with those countries. My most interesting experience with tribunals was with the Special Court for Sierra Leone. Special Court for Sierra Leone was a tribunal that was set up pursuant to an agreement between the United Nations and the government of Sierra Leone to prosecute those most responsible for war crimes in Sierra Leone. As you may remember, there was a terrible civil war going on in Sierra Leone in the late 1990s, early 2000s. There was on the one side the government, on the other side there was the Revolutionary United Front led by Foday Sankoh. And it was mainly the RUF that committed horrendous crimes of cutting off people's hands and arms. It was a fairly brutal, or very, very brutal civil war. And the government of Sierra Leone at the end of that civil war decided, with the support of countries, to establish the small court to prosecute those most responsible. In the end, 13 individuals were indicted, including the former president of Liberia, Charles Taylor. Charles Taylor subsequently moved from Liberia to Nigeria, where he was granted a certain form of protection by General Obasanjo, the president of Nigeria. But there was huge pressure on President Obasanjo to deliver Charles Taylor to the Special Court for Sierra Leone. The Security Council adopted a decision under Chapter 7, which meant it was binding, that if Charles Taylor arrived in Liberia, his home country, then the UN in Liberia had the authority to arrest him and to bring him to Sierra Leone. One day in March 2006, I was heading to Sierra Leone for a visit. I was just the desk officer, and I got a call from the Secretary General's office to say, President Obasanjo has just talked to the Secretary General, Kofi Annan, and he has committed to delivering Charles Taylor to the court. We know you're going out there. You are our guy on the ground. Gosh, I'd never done anything like this in my life before. And so I flew to Sierra Leone and then took a helicopter from the airport, crazy helicopter, to the center of Freetown. And as I arrived and descended, staff were waiting for me. They handed me a phone and said, this is your phone. You communicate with the Secretary General on the basis of this phone. And then we all waited. We waited in Freetown, great place, what would happen. And then Charles Taylor did us all a favor. He tried to escape. And he tried to move from Nigeria into, and at the border, very, who are you? And Charles Taylor, the immigration officer said, open up the boot of your car, take with 2 other people. So Taylor handed him some money and said, no, here's some money, just wave me through. And because this was ECOWAS, the immigration officer could have done that. He could have waved Taylor through. The immigration officer said no. He said, open your boot. So Taylor opened his boot and there was an enormous suitcase full of cash. So the immigration officer said, hang on, this is just not okay. He started calling. Within 5 minutes, they knew exactly who this person was. President Obasanjo was furious and he said, immediately repatriate Taylor immediately. I was on the ground in Freetown, Sierra Leone, and immediately we put the machine into action. Nigeria flew Taylor back to Monrovia in Liberia. In Monrovia, he was met by our staff. They had the Chapter 7 mandate to arrest him, so they arrested him. Then a thunderstorm broke out, so he couldn't travel by helicopter to the Special Court for Sierra Leone in Freetown. It was already 12 noon. I was afraid that that they would not be able. We had no facilities for holding Taylor at the airport. Anyway, then we lost contact with Monrovia. We completely lost contact. But in Freetown, we were making preparations to receive Taylor. And then I was in the chief prosecutor's office when I heard this screams and screams outside. And we all ran outside and we saw these 2 helicopters circling over the Special Court for Sierra Leone. He'd arrived. The helicopters went out into the ocean. The Special Court was situated close to the ocean. The helicopters went out into the ocean so that the pilots could adjust themselves to the night light. The helicopters came back, slowly landed. Mr. Taylor got out of the helicopter and he came into the detention center. We booked him. We did all the necessary paperwork, and then he spent the night of course, in the detention cells, and then there was subsequently a trial. And that night, there were celebrations in Freetown like I've never seen before, because someone that had caused so much harm was finally being brought to justice. And that, to me, was a living witness as to what international law can do. As I said, there was subsequently a trial, and he is now imprisoned for life in the United Kingdom. So that's my little story about the Special Court. In 2002 to 2006 to 2008, I was Chief Legal Officer in Sudan. That was a very interesting experience in Khartoum. Again, there was a lot of work with the government in order to facilitate our work, protection of privileges and immunities. We also set up a peacekeeping operation in Darfur, Sudan, with the African Union called UNAMID. And again, there I saw international law in motion, because the moment we had set up that peacekeeping operation, we could bring more troops. The AU did have troops there, but we could bring more troops. We could bring police observers, military observers, and we managed to establish a sense of calm in Darfur through the legal arrangements that we had established. Between 2008 and 2017, I was back at United Nations headquarters. I did a lot of intergovernmental work. I went to the Rio Plus 20 conference in Rio de Janeiro that was the precursor to the Sustainable Development Goals, and helped negotiate that. And then I worked on United Nations commissions of inquiry, and these are really where the United Nations establishes a commission in order to investigate a particular event, like we did for Benazir Bhutto's assassination. Although we do not highlight the role of individuals, it's more a facts and circumstances type of commission of inquiry. And then in 2017, I came to UNEP, which is where I am at the moment, and I will touch upon that a little bit later. Next slide, please. Now, often UN funds and programs have their own legal offices. UNDP has their own legal office. UNICEF has their own legal office. UNEP divides its legal work between corporate, within our corporate services division, which focuses on private law questions, and then the law division that focuses on the progressive development of environmental law and support to intergovernmental processes. And I will touch, I see there's a question related to that. I will touch upon that. Next slide, please. Now, what does the UNEP Law Division do? Now, the UNEP Law Division examines often frontier issues in environmental law, including those that have been identified by the United Nations and intergovernmental bodies, such as the General Assembly or the UNEP Committee of Permanent Representatives or the Environment Assembly. Its principal purpose is to support the progressive development of environmental law, because a lot of environmental law has already been codified in terms of treaties, whether that is the Framework Convention on Climate Change, whether it's the Paris Agreement, whether it is the Convention on Biological Diversity, whether it's the Minamata Convention on Mercury. So a lot of that has already been done. But our role is often to identify key issues. And for example, the Human Rights Council recently adopted a resolution on enjoyment of a safe, clean, healthy, and sustainable environment. And so what does that mean? And so part of the law division is to explore that. We also, through our Montevideo program, that will be one of the next slides, we look at emerging environmental issues as well. And we also do a lot of research and studies and reports on emerging environmental issues. Next slide, please. Now, our flagship program is the Montevideo Environmental Law Program that basically helps states strengthen environmental legislation and legal framework, implementation of environmental law, and basically helps countries also through capacity building implement environmental law, and also helps with the development of model laws. So if you want a model law on air pollution or clean air, then you can come to us and we can help you. We can help you with environmental governance and help you with your Ministry of Environment, should you wish to do so. But the environmental law program is to support environmental legislation and legal frameworks. How do we do it? We work with national government focal points. There's a steering committee. We partner with other UN agencies and IGOs and civil society, because UNEP, pursuant to its mandate, is really the centrifugal point, the focal point for environment and environmental law. We also have academics that do research. We partner with the private sector, because to be green now is always good. So that is really what the Montevideo Environmental Law Program does. Next slide, please. Now, another important part of our work is environmental governance. And we address what we call the triple planetary crisis. And what we mean by the triple planetary crisis is the crisis in climate, the crisis in biodiversity, and the crisis in pollution. Through developing effective environmental policy and governance mechanisms. Now, what has happened in environmental law is that the approach has often been siloed. So you had the Framework Convention on Climate Change that dealt with climate. You had the Paris Agreement that dealt with climate. You had the Vienna Convention on the Protection of the Ozone Layer and the Montreal Protocol that dealt with the ozone. You have biodiversity that is dealt with by a specific convention. You have CITES. You have the Basel, Rotterdam, and Stockholm Conventions that deal with chemicals and waste. So all of this is siloed. And one important contribution that we make is that we facilitate dialogue and cooperation on horizontal issues of common interest. So through UNEA and our MEAs and governing bodies, because the United Nations Environment Assembly also adopts important resolutions. Multilateral environmental agreements through their governing bodies adopt important decisions. And our role is really to help make sense of all of this, help countries paint a picture so that they can navigate this complex world of environmental treaties and decisions that are taken by bodies. And also have what we call whole of government approaches, where we can bring people together in a particular government and so that they can understand the broad picture of environmental governance and how we can help and support them. Next slide, please. So that's it. Triple planetary crisis is climate, biodiversity, and pollution. It's addressed mainly through conventions, i.e. treaties, climate, Framework Convention on Climate Change, UNFCCC, Kyoto Protocol, Paris, biodiversity, CBD and CITES, pollution, Basel, Rotterdam, Stockholm Conventions, Vienna Convention on the protection of the ozone layer. Next slide, please. So this is kind of, I'm now coming more to the end of the presentation. Lawyers have traditionally done a lot to support intergovernmental bodies. So United Nations Environment Assembly is our highest decision-making body. It consists of 193 member states. And then we have an intersessional body, the Committee of Permanent Representatives, that sits here in Nairobi and that meets between the sessions of the Environment Assembly. Now, how do lawyers support this process? Well, first of all, we provide support on the interpretation of UNEA's mandate. What can UNEA do and what can't UNEA do? We inform member states on previous decisions that have been taken by UNEA. In other words, what is the history of UNEA and its predecessor, the Governing Council? We review draft decisions that come before UNEA. Then we advise on what we call credentials. If you are a delegate, you can't just pitch up or send an email, say, hi, my name is Stadler, I'm going to pitch up. You have to provide a formal credential, which is a formal letter from a head of state, head of government, or Minister of Foreign Affairs, or from your foreign ministry that accredits you. And we review that in order to make sure that the accreditation is in order. We advise the presiding officer, such as the president of the Environment Assembly or the chair of the Committee of Permanent Representatives, on rules and procedures and processes, so that if someone makes a point of order, then the lawyer can help the presiding officer deal with that point of order. We also advise on the election of officers, because every large body has what we call a bureau that consists of representatives from member states. And the bureau is like, deals with the organization of that meeting, and there are elections to the bureau. We conduct those elections. I recently came back from Bangkok, where we had an election for a bureau that is dealing with science and policy. In addition, we provide support to subsidiary processes. One of those that is kind of going on now, that is getting a lot of attention, is the Intergovernmental Negotiating Committee, or INC, to prepare a draft treaty on combating plastic pollution. And one of our roles here is to help prepare the first draft of this treaty, or elements of the draft, for consideration by member states. My final slide, please. Now, if you want to come and work for us, what are the options? Now, there are internships, but internships are unpaid. Then you can become a United Nations volunteer, UN volunteers. They are headquartered out of Bonn, Germany, and they send UNVs all over the world. UNVs are paid. They do get a stipend. And you can move from UNV to a professional officer. So it provides a segue into the UN. Then there are JPOs, junior professional officers, that come from member states. So France can subsidize JPOs, usually the rich countries of the world, Sweden, usually the rich countries subsidize JPOs. I think there are some developing countries that do so as well. And then you can apply for professional positions. Now, oops, the slide has gone off. There we are. Now, the two websites you should be aware of are careers.un.org, that deals with United Nations careers, and then jobs.unicsc.org. Now, what is UNICSC? UNICC stands for the United Nations International Civil Service Commission. Now, going back to what I said at the beginning of the presentation, there are many organizations that, like specialized agencies, that look like the UN and are affiliated with the UN, but are not UN. I mentioned the Food and Agriculture Organization, the World Health Organization, World Intellectual Property Organization. They look like the UN, but they're not UN. They are separate international organizations. So their jobs are not on the UN Careers website, but are on the UN ICSC, United Nations International Civil Service Commission website. Now, you don't only have to apply for a job in Kenya, you can apply for a position all over the world. But importantly, all jobs are advertised online. The UN does not accept hard copy applications anymore. All applications have to be done online. Now, make sure that you meet the requirements of the job description. You need to make sure that you meet all the job description. The JO will have various requirements. You have to meet them. Sometimes it will indicate that a particular attribute is desirable, for example, like a second language, like French is desirable. But if they say something is required, like 8 years of professional experience is required, you have to meet that requirement, because all applications are scrutinized by human resources before they send to us. And human resource application if it does not meet the requirements. So you need to put an effort into your application and tailor it to the job description. Now, there is also the possibility of an examination followed by a competency-based examination, which is an oral examination. So there is a written examination where you are tested on the work of the job description, and then you have an oral examination. Now, importantly, the oral examination is exactly that. It's an examination. It's not a chat. It's not a friendly chat. And you are examined on various areas of various what we call competencies. Professionalism, usually you have to cite an example of your professional skills and how that meets the job description. And then the job description would have various other requirements, such as teamwork, communication, leadership, management. And then you have to provide examples. Speak slowly, but provide examples. So a classic question is, give us an example of how you communicated complicated legal concept to a delegate from a member state, or how you communicated a complicated legal concept to a non-lawyer who was your colleague. Teamwork. Please provide an example of where things went wrong in a team and then how you put them right. On management, please give an example of how you dealt with a difficult staff member. On leadership, sometimes the questions are more open. What is your view on leadership? What do you think your qualities as a leader are, and how would you implement them? But the focus with these UN jobs is on examples, providing examples from your professional career. And remember to speak slowly. So that's my presentation. Thank you so much for listening to me. And now I'll hand over to Annabelle, and I am assuming there are questions in the chat. Thank you.
Thank you, Stadler.
So there was a question from an anonymous attendee that says, I have a question on the extent of PNI. Does it only apply to UN staff, or can UN contracted partners or agents? So yes, the arrest of NGOs is a difficult issue. It happens far too frequently. The legal answer is the Convention on PNI, because again, it is a treaty, only applies to UN staff and what we call United Nations experts on mission, like consultants, but it would not apply to NGOs. NGOs often have their own agreements with host countries, and they should rely on those agreements. Then Alex Chirongas asks about the UN Security Council. Yes, I mean, that's a good question. Reform of the United Nations Security Council and consideration of the veto has been going on since 1997 at the United Nations, but nothing has happened. Nothing has happened. Will the Russia-Ukraine situation change that? Frankly, I don't know. But of course, the reason why the Security Council cannot act is because Russia has a veto on the Council. The legal implication of sanctions issued by US, USA, EU, and UK against Russia, not for us, because as I've said before, we are governed by our own intergovernmental bodies. Now, the anonymous attendee said, how necessary is it to be fluent in multiple languages at the UN when working as a legal officer? What key skills can a legal officer cultivate now to prepare for a UN career? So, good question. The United Nations Secretariat has two working languages, that is English and French. So my advice is often to to the extent possible, fluent in both, because a job description at the UN can require fluency in French, fluency in both, or that you have to be have a working knowledge of the second language. I've managed to build a career in the UN by having very limited French, but having French as a language you can speak and write and work in will definitely help you. Other languages, perhaps Spanish, because we do a lot of work in South America, but definitely English and French. What key skills can a legal officer cultivate? Study international, do courses in international law. Again, go onto the UN Careers website and have a look at the job descriptions for junior officers and see what they ask for. Because sometimes they do ask for a master's degree in international law. So have a look at that. But studying international law, and of course international law is a very broad subject now, but customary international law, environmental law, law of the sea, disarmament, international peace and security, these are all relevant, but anything under public international law will do. What qualifications does, again, anonymous attendee, a Kenyan lawyer, trained lawyer required to work at UNHQ? Again, that would depend on the job description. There was a Kenyan lawyer that worked for us here in Nairobi, and he then moved he applied, he got into UNEP, and then moved to a position in New York where he currently serves. But again, generally speaking, not only for Kenyan lawyers, but for other lawyers as well, we require a first degree in law, and then a second degree, like a master's in international law, or if you're in environmental law, although a certain number of years of experience can be used in lieu of a second degree. I'm not sure how many those are, but to be safe, it's usually first degree in law with a second degree in international law. Duncan asks, how many hours is the president? Specific facts of a case, so I'm not really in a position to advise on that. Do you need to know all the nitty-gritties of operations of the UN as a body when putting together an application? Absolutely not. Again, we have a system in the UN. You usually join. I joined in 1998 as a P2. Then you go up to a P3, P4, P5. Then you have director level, D1, which is regular director, which is my level. Then you have D2, which is senior. It depends very much, again, on the expertise you can bring to the United Nations. But obviously, for any UN application, you have to have a basic idea of what the UN is about, and you have to have a basic idea of the office which you are entering into, but that you can usually get from the job application. How easy is it to transition from private practice to working with the UN? In terms of private law, you can totally do it because we have a lot of private law. And so those of our colleagues that are in private law, some of them have actually come from private practice. Would you encourage someone, this is a good question from Anonymous, would you encourage someone who is interested in working with you and to start with general service before going to professional? Not necessarily, not necessarily, because there is kind of this concrete wall between general service and professional. There is an examination that they call G2P, where general service write an examination and then you can move to the professional. Getting through that examination is almost impossible. And the reason why is that it is not difficult to pass, but they only say take the top 5 out of like 200 applicants. So it is very difficult actually to move from G to P, from general service to professional. What tips, what key would you have for a person interested in applying for an internship? Again, have international law as part of your undergraduate, have law. Again, I'm speaking about law. Internships are also advertised online, so read the job description. Interns are upset at the moment because they don't get paid, which is probably a fair point. Will that change? I don't know. But if you do an internship, you have to be prepared to volunteer your time and go into that with open eyes and an open mind. But what you get in exchange for that is you get access to the UN, you get access to colleagues, you can understand how the organization works, that hopefully can put you in line for applying for a position at the UN later on, although there is a break in service that is required. What are the key legal skills required for practicing law in international institutions? Again, I would say a first degree in law. So, often you will have someone that did a Bachelor of Arts, then a Bachelor of Law, and then a Master's in Law. I would highly recommend a Master's in International Law or a Master's in International Environmental Law. What are the key skills we look at? We look at the ability to, of course, knowledge of international law is important. That's very important. Number two, an ability to think analytically is important. Ability to conduct independent research. So that's why often, masters, people who've done masters are attractive to us. If you've done a thesis, the ability to conduct independent research and the ability to draft well, because so much of what we are doing is in form of the written word. Is it superior? Yes, go on to UN careers as the United Nations careers. Just Google United Nations careers, and then through United Nations careers, then you get access to the hiring platform. So this is an interesting question about Charles Taylor. My question comes from the arrest, trial, and imprisonment of Charles Taylor. 2 years ago, I met his wife in Kenya. She said that Prince Johnston, who something Samuel Doe on TV, is a member of parliament in Liberia. More significantly, if Taylor was free, he would be elected president. Mrs. Taylor is currently the vice president. So to what extent has international criminal justice principles been foisted on local populations? Do ordinary people understand the UN's role with the international community undemocratic? There's no outreach to teach people international values. So the point about the Yugoslav tribunal as well as the Rwandan tribunal was that they were situated outside Eastern Europe, outside the Balkans. So the Yugoslav tribunal was situated in The Hague, and the Rwandan tribunal was situated in Arusha. So that did create and lead to complaints that this was not that the entire process, either in Arusha or in The Hague, was disconnected from local. Disconnected from the local populations, that the local populations didn't know what was happening. Importantly, the Yugoslav tribunal was created by the Security Council. That there was no agreement between the former Yugoslavia, and the UN on this tribunal. Similarly, for Rwanda, it was created by the Security Council. There was no agreement with Rwanda. And it was very important to appreciate that while the activities of the tribunal were going on, the Rwandan government definitely had views on the work of the tribunal. For Sierra Leone, we adopted a different approach. Sierra Leone, we did not go to the Security Council. There was an agreement between the government of Sierra Leone and the United Nations to have this tribunal. This tribunal was not based out of a foreign country. It was based in Freetown. So the local population had access, and indeed we encouraged visits to the court sessions in Freetown, Sierra Leone. Now, for Charles Taylor, it was different because he made his initial appearance in Freetown, Sierra Leone, but then his trial was moved to The Hague. The decision was taken because it was believed that basically it was a trial that was too hot to handle in West Africa, and it had to be moved to The Hague. Whether that was wise or not, I don't know, but that was the decision that was taken. I think the UN adheres, going back to this idea of undemocratic. There can be no peace in any community without justice. And the focus of the UN is always that local and national judicial institutions should assume that role. But often the events that have unfolded in a particular country are so catastrophic that the only possibility is for there to be some type of international process. Are there any plans to translate UN instruments to Kiswahili? Not that I'm aware of. Again, the UN publishes its documents into the 6 official languages of the United Nations: French, Russian, Chinese, Arabic, and Spanish. We publish in those languages, but we don't publish into any others. Then Maureen asks, how long does it take to have a UN convention codified in law? Last November, there was an adoption of a resolution calling on member states to lay the groundwork for a UN convention on tax that would give low and middle-income countries decision-making power over global tax affairs. Now, it takes a while. All right, it can take a long time. Currently in New York, they are negotiating what they call the BBNJ Convention, which deals with how we treat the high seas beyond the national jurisdiction of states. It's a process that began 6 years ago. So often, in the case of the plastics treaty that I'm involved in to combat plastics, they hope that negotiations will only last 2 years. But you have to have a resolution from a UN body. You have to have the establishment of an intergovernmental negotiating committee that's in essence really a legal committee to negotiate the treaty. Then you have to have a plenipotentiary conference where the treaty is signed. Then it goes to the depository, the Secretary General. Then the treaty has to be ratified. And only once it's been ratified by a certain number of member states can it enter into force. So it is a while. But again, it depends on how pressing the international community regards the issue at hand. So how does the UN resolve employment disputes? That's a good question involving privileged immunities. Staff members of the UN have the right to take their employment disputes to our UN administrative tribunal. Zena Rashid is, I'm blind, how would I be interviewed? The UN does welcome applications from individuals that have physical as well as emotional disabilities. So if that was stated on the application form, then I'm sure we would find a way in which to interview you. And thank you very much for that question. There is actually a United Nations Convention on the Protection of Persons with Disabilities, and we are completely committed to that convention and the people that it covers. Then the anonymous says, say you have 10 years of work experience. The best thing to do for volunteers is to go onto their website. Just Google United Nations Volunteers, Bonn, Germany, and you'll get your answers. Should persons interested in the UN pursue UNV positions, and what are the likelihood of someone working with the UN when the assignment period ends? So yes, I would definitely say pursue a UNV position. Obviously, positions for professionals can be hard to come by, but the whole idea behind a UNV position is once you are a UNV, you start exploring what else is out there within the UN. And at UNEP, we've employed several UNVs and intend to employ more. Would you consider anonymous dispute resolution skills, for example, court? Yes, we would. In international arbitration, definitely we would. Court litigation is very relevant when it comes to, for example, defending the Secretary General before the UN Administrative Tribunal. The UN is doing many positive things, at least from your presentation. Is this information publicly available? Yes, UN funds and programs like UNDP, UNEP, UNICEF have separate websites. The United Nations Office of Legal Affairs has a separate website. So there are many, many websites that deal with that, deal with what we are doing. And then it says, how do factors such as wealth, power, and geopolitical interests affect the implementation of international criminal justice? As you've seen, a lack of interest by international institutions to prosecute the condemned atrocious acts done by more influential, rich, and powerful countries. I think this is an issue that is very much out there in international relations. If you have a look at the International Criminal Court, there are certain countries that support it. There are certain countries that don't. So the prosecutor is supposed to be completely independent, and any good prosecutor goes where the evidence leads them. And so it is very, very important that international tribunals not be political tribunals at all, that international tribunals be courts of law, and that individuals go, and that the prosecutor and finally the judges go where the evidence leads them. What is the process of joining the Montevideo program? There is a website. We have national focal points. So every country has a national focal point that joins. But actually, just Google UNEP Montevideo program, and then you will see all the information. Then finally, I'm aware of UN Convention, encourage nations to legislate. Are you aware of any? What are the possible challenges? Yes, obviously, lawyers have to be protected in the independent performance of their functions, but ultimately it is up to every single member state to take that convention and implement that in their national legal system. Okay, I think I've spoken enough now because we're going on actually for an hour and a half. So Annabelle, back to you. Thank you so much.
Thank you, Stadler. I hope the members enjoyed the session. Judging by the comments I'm seeing in the chat section, I think it's safe to conclude they have. We've had an average of 200 members attending today, so you've done very well. Thank you all for making time. Next week, we're going to be having a session on same place, same time. March is going to be a month on matters taxes. So we're going to be talking about litigation and ADR at the Tax Appeals Tribunal. Then there's going to be a session on capital gains tax. And then afterwards, there's going to be a session on taxation for your legal practice. So be on the lookout for the posters and the link. Make sure you register in good time and be sure to attend the session. Thank you so much, Stadler. We're going to be sharing your presentation with the members. So also remember to check out, be on the lookout for emails from LSK. That's how you're going to access the presentation. Yeah, I believe if you want us to have him again, be sure to let us know, and we'll find a time and date that works for him and us as well. So I think it's okay for me to end the session. As LSK Secretariat, Emily and Sophie, thank you so much for facilitating this session. Mubarikiwe sana. Have a lovely afternoon and evening, Stadler, and to the members.
Thank you. Thank you so much. Bye-bye. Lovely to meet all of you online. Bye-bye. Bye-bye.
Okay, bye-bye.